Hi, my name is Vigines and Shankar and my metric number is 454481. Okay, today I'm going to talk about the Dworkin right thesis. So the background for the theory is the judiciary plays an important role in all legal system. But the question is, how does a judge decide a case? If a case is brought to the court, the judge cannot refuse to adjudicate it on the basis there are no precedents, or the lawyer cannot cite any authority on the point of law. But in this connection, Dworkin observes that there is a right answer to each case. Dworkin's right thesis involves the general claim that within legal practice and proper understanding of the nature of law, the rights are more fundamental than rules. This is obviously claimed to most legal positivists. Rights are trump in Dworkin's theory, which means that if there is any rights which comes into conflict with any policy, the rights must prevail. Okay, now we go to contribution of the Dworkin in this theory of rights. There are four main points or ideas that have been contributed by Dworkin. First is judicial discretion. Dworkin wishes us to consider carefully what lawyers are actually doing as a matter of legal principle in hard cases. Discretion is not freestanding but part of a process. If judges simply exercise discretion and make a new rules, they will be changing the rules of a game. Each time they do so, they will commit a fraud on the litigants. Dworkin has an alternative theory. The first step is to make a distinction between strong and weak discretion. Strong discretion is where the officials are bound to be pre-existing standards set by the authority. The weak discretion is when the standard cannot be applied in a mechanical way. In a weak discretion, there is a gap in the law, no gap in the law, but the strong discretion does not exist for the judge. While the weak discretion is a part of a judicial rule, the discretion is controlled and there are no gaps in the law. For the second, it is legal rules versus principles. Legal rules and principles for the Dworkin exist to express and protect rights in a legal order. For Dworkin, the central approach within the law emphasizes rights and the protection of the individual, including the protection of minorities who are left out of the consideration of the utilitarian. The idea that laws are rules induces distortion in legal reasoning. Instead, we must distinguish rules from principles, the policies, and other non-law standards. In the operation of legal system, policies are not appropriate to legal reasoning, and principles are more important than rules as they surround this stretch of rules. And for the third, principles and policies, Dworkin brings out a distinction between principles which relates to the individuals, whereas policies identify the collective goals. Dworkin not in favor of a judge using the policies in interpreting laws. He is in favor of giving discretion to judges. Dworkin believed that by using a ways of policies to give a decision, it does not have a strong gravitational force as how the precedent cases had. And for the laws of interpretive concept, Dworkin says that the laws has its own way to be interpreted by the humans. Interpretation is an important guide on us how to interpret the laws. Thus, he developed three main stages of interpretation idea to show that the way of interpret the law based on different three stages. The first stage is pre-interpretive, the second is interpretive, and third is post-interpretive. Moreover, Dworkin had also contributed his ideas on the manner of treating people as equal and equality, right to speech, imaginary auction theory, concept of integrity, and as well as the feminism. For the third part, the example of law is promissory estoppel, and the case based on the case in Riggs versus Palmer. In this case, Elmer murdered his grandfather in order to inherit his wills. The court did not allow the Elmer to profit from his own wrong. That decision proceeded not on rules but on a principle of law. That is, no one can profit from his own wrong. Similarly, Lord Denning's development of promissory estoppel doctrine in high-three cases are similar to the cases of Riggs versus Palmer. We can see that the rules have a different meaning and different effect when you apply relevant principles. Whereas these policies are the collective goals of society pursued by the legislature, democratically elected. Principles are internal to law and are developed by the judiciary. So the rules that a person may be not benefit from his own principle is a principle which is found throughout the law. For Dworkin, judges are always constrained by the law. There is no law beyond the law. In every adjudication of hard cases, there are controlling standards which the judge is obligated to follow. Judicial decisions are generated by the principles and enforces existing rights, so that the litigants are entitled to the judge's best judgment about what their rights are. Judges are Judges may not rely on their own political views, but only on their belief in the soundness of their contributions. As a conclusion, Dworkin's one right answer thesis is crucial for understanding Dworkin's entire political and legal theory because of their theology reliance on the status of value, particular moral values. Dworkin thinks that the law is a branch of political morality which is a part of general morality, and which is in turn an extension of personal ethics. For him, legal argument is a special kind of moral argument that concerns with moral justification. Dworkin's right is one as to not relent but to make the utmost effort to get the best answer. It is a sort of ideal that Dworkin seems to present to the judge in a practical pursuit. Dworkin's work has consistently been concerned with judicial interpretation of law and the role of judges. Dworkin is clear as to the political values he is committed to. His philosophical stresses a right approach over utilitarian calculations. One of his famous quote is, "This is what law is for the people we want to be and community we aim to have." With that, I end my discussion today. Thank you.